Hi everyone, and welcome to the Daubert Trilogy video lecture. Let's get started. Now the Daubert Trilogy is one of the most significant cases for expert testimony because this trio of cases is the most commonly used admissibility standard today, even though it still varies between jurisdictions. Daubert involved a civil case. Jason Daubert and Eric Schuler were both minor children who were born with serious birth defects. Now both of their mothers took a drug called Benedictine during their pregnancy. Benedictine was marketed by Merrill Dow Pharmaceuticals as an anti-nausea drug for pregnant women. At the beginning of the case, Merrill Dow moved for a summary judgment, meaning that they asked the court to make a decision before it even came to trial that there wasn't enough test evidence to prove the link between the drug and the birth defects. Now, both sides had expert witnesses testifying about the drug effects. Merrill Dow had an expert, Stephen Lamb, who was a physician and epidemiologist that focused on the risks of exposure to various chemical substances. Lamb testified that there was a lack of published scientific research that showed a link between Benedictine and birth defects, and he noted that he had reviewed over 30 published studies that involved over 130,000 patients, and he said that there was no evidence supporting the role of Benedictine in causing birth defects to fetuses. Daubert and Schuler had 8 expert witnesses on their side, and they argued that Benedictine was related to birth defects. Now, their experts acknowledged the fact that there was no published studies supporting this link, but they based their opinions on the result of test tube in vitro studies, live animal research, and the unpublished reanalysis of previous human research studies. After listening to both sides, the judges granted this summary judgment, holding that the evidence put forth by the 8 witnesses did not meet the general acceptance standard that was required by CRIJ. And the Court of Appeals upheld this decision. And again, they noted that CRIJ calls for general acceptance, and so this evidence did not reach the standard that was required. The case then went on to be reviewed by the United States Supreme Court. The plaintiffs argued that the Federal Rules of Evidence 702 superseded the CRIJ standard, and as such, the evidence did not require to be proven as generally accepted. The Supreme Court agreed. The defense also noted that when 702 was written, it specifically avoided the wording of general acceptance, and therefore it was clear that the admissibility standard of general acceptance should not be applied in federal courts. In their decision, the Supreme Court ended up writing out more detailed guidance that relating to scientific evidence admissibility, and these guidelines later became known as the Daubert standard. The Daubert standard consisted of 5 criteria. The first was whether the theory or technique in question can be and has been tested. The second was whether the technique or theory has been subject to peer review and publication. The goal of this standard was to address the junk science issue that, all the other ones try to address as well. Even if the junk science can be tested, once it's subject to peer review, it's unlikely to get published because experts in that relevant field will be able to identify the problems inherent in the design. Now, the third criteria asked what the known or potential error rate of the technique was. And this is something that forensic science has really struggled with post-Daubert, because most of our analyses were grounded in historical, not statistical methods, so there hasn't been any calculated error rates. In fact, for a long time, the FBI argued that fingerprinting has a 0% error rate because the method itself was error-proof. Now, obviously, this is untrue, because any analysis that involves a human, you're going to have an element of human error involved in both the analysis and the conclusions. Even when I was in graduate school, so not that long ago, the FBI was actually promoting the 0% error rate testimony, although they have now stopped doing this since, but it's relatively recent. Now, the exact process of determining fingerprint error rates, including whether the individual analyst should be rated based on their error rate and what error rate is too high, all of that is still up in question. Now, the fourth criteria for Daubert, are there standards and controls governing the process of testing? This means that there are ways to evaluate the test or the technique that remain consistent. For example, there's a government agency called NIST, the National Institute of Science and Technology, that provides collaboration services for forensics laboratories. If you want to make sure that your breathalyzer test is working, for example, they can provide you with a sample that contains a known amount of alcohol. You can test your device to see if the breathalyzer reports the right number. By using this standard, laboratories all over the country can make sure that their equipment is functioning properly and accurately. So this criteria basically means is there something equivalent that ensures that the test or the technique is functioning properly before they use it? Now, finally, the Daubert standard also includes the fifth principle is the idea of general acceptance. The judges noted, though, that these 5 criteria, including general acceptance, were not required for every case. They instead discussed how the rules of evidence were specifically designed to be flexible to different cases and circumstances, and they said that they wanted to ensure that the future admissibility tests remained so. The judges wrote that, quote, "The inquiry is a flexible one, and its focus must be solely on principles and methodology, not on the conclusions that they generate," end quote. Now, in addition to the clarification of the evidence admissibility process, another important ruling to come out of Daubert was the role of the judge as gatekeeper. The Supreme Court noted that the rules of evidence the rules of evidence expressly provides for the judge to make the determination as to whether or not the scientific knowledge will help the trier of fact. They then confirmed that it would be the role of the judge, through witness examination and cross-examination, to determine whether or not the scientific evidence would be admissible in court. The justices acknowledged that this process would not be perfect, noting that at times the screening process would, quote, "prevent the jury from hearing of authentic scientific breakthroughs," end quote. But that it was, quote, "simply a consequence of the fact that the rules are not designed to seek cosmic understanding, but rather to resolve legal disputes," end quote. So basically, we might not always get it right, but we're trying to do the best we can, and we're going to do that through the adversarial process that our criminal courts are based on. The second part of the Daubert trilogy came about a few years later with the General Electric versus Joyner case in 1997. This case also involved a civil case. Joyner was an employee of General Electric who developed small cell lung cancer. He sued General Electric, arguing that this cancer was in part caused by his workplace exposure to carcinogens in the workplace. Specifically, Joyner argued that his work exposed him to polychlorinated biphenyls, PCBs, which are considered hazardous to human health. In fact, PCBs were banned in 1978 as a result of the hazards that are related to these chemicals, but they were found to have contaminated the coolant fluid that was used in the electrical transformers that Joyner worked on. Now, however, Joyner also had a family history that contributed to his cancer. Joyner himself had been a smoker for 8 years, his parents were both smokers, and there was a family history of lung cancer. Joyner's suit alleged that the PCB exposure he suffered at his workplace exasperated his risk, making it more likely that he would get cancer quicker. GE asked for a summary judgment, and remember, that means it goes away before it even goes to trial, and they argued that Joyner's claim had no basis in scientific evidence. Joyner responded with 3 expert witnesses that testified that PCBs can cause cancer, and therefore Joyner's exposure to PCBs through his work was likely responsible for his small cell cancer. The judge sided with GE, noting that Joyner's experts did not prove the link between PCBs and small cell lung cancer beyond a subjective belief or unsupported speculation. Now, Joyner appealed the summary judgment to the Federal Court of Appeals. The appeals court reversed the lower court's decision, and they argued that the rules of evidence are more lenient towards admissibility than exclusion, so the judge should not have excluded the evidence without more stringent proof that it was actually inadmissible. General Electric then appealed the appeals court's decision, and the case goes to the Supreme Court. At this point, the Supreme Court reverses the decision of this appeals court, so it keeps with the summary judgment from the original court. The court ruled that the role of the appeals court was to review admissibility standards only, not the science itself. And this is a really important solidification of the Daubert's decision's gatekeeping role for the judge. What the Supreme Court decision in GE versus Joyner did was make the admissibility decisions of a judge very difficult to overturn. Based on this decision, the appellate court can only overturn a ruling when there is a clear abuse of discretion, meaning that the judge did not make a sound, reasonable decision. So long as the judge approaches the argument logically and reasonably, the admission or exclusion decisions cannot be appealed themselves. Now, the Supreme Court decision also supported the exclusion of the evidence in this particular case because of the difference in facts between the facts in question and the scientific tests. Joyner's exposure to PCBs came about as a result of interaction with liquid coolant that contained these PCB particles. Joyner's experts, though, came to their conclusion about PCBs and lung cancer by using animal experiments in which mice were injected with highly concentrated doses of PCBs directly into their body. The Supreme Court noted that it was reasonable for the judge to exclude this evidence because the situation that was being tested was distinctly different from the reality of the case, and thus could not provide relevant information to the trier of fact. The last part of the Daubert trilogy comes from the Kumho-Tyre decision in 1999. In Daubert and Joyner, at issue were scientific medical studies. Rule 702 includes the idea of this specialized technical knowledge as well. What was unclear until the Kumho-Tyre case was what technical knowledge would be handled under, or how technical knowledge would be handled under a Daubert framework. Kumho-Tyre versus Carmichael was another civil case that was stemming from a fatal car accident in 1993. As Carmichael was driving, a rear tire blew out, causing an accident that resulted in one fatality and several serious injuries. The Carmichaels sued the tire company, arguing that the tire itself was defective and therefore the cause of the accident. The Carmichaels had an expert, Dennis Carlson Jr., who was an expert in tire failure analysis. Carlson Jr.'s testimony was objected to by Kumho-Tyre and was excluded from evidence by the judge at the original trial as being unreliable. At that point, the judge then granted a summary judgment for Kumho-Tyre. Now, the Carmichaels appealed to the Federal Appeals Court, and they reversed the lower court's summary judgment. The appeals court argued that the judge did not have the right to exclude Carlson Jr.'s testimony because the judge's gatekeeper role under the Federal Rules of Evidence only applies to scientific evidence, not technical or experience-based testimony. Kumho-Tyre then appeals the appeal all the way to the Supreme Court, and then the Supreme Court overturned the appeals court's decision. So we went back to the original decision. The Supreme Court ruled that the rules of evidence make no distinction between scientific, technical, or other specialized knowledge. And so they said all of those testimonies will be treated the same, and they all fall under the gatekeeping role of the trial judge. Therefore, the original court's ruling that excluded Carlson Jr.'s testimony on the basis that his methodology was not reliable was within the court's discretion and could stand. So what do we end up with as a result of the Daubert trilogy? The original Daubert ruling gives us the decisions that the judge is the evidence gatekeeper, using a set of 5 criteria to evaluate scientific evidence, but also getting the discretion to apply or not apply each criteria on a case-by-case basis. The GE versus Joyner case strengthened this gatekeeping role, noting that only gross abuses of discretion could be overturned on appeal. And then the Kumho-Tyre decision expanded the coverage of the Daubert criteria to include both technical experience and skill-based knowledge, as well as scientific evidence as was originally understood. The chart on this page shows where we are as of 2019. A large majority of states use some form of the Daubert decision and the Federal Rules of Evidence as the basis for admissibility decisions. Texas is one of those states that uses a modified Daubert called the Robinson Challenge, which has 6 principles, but the principles are pretty much based on the same concepts as the original Daubert decision, like known error rates, peer review, general acceptance. There are several states, though, that continue to rely on the Frye decision of general acceptance, and there are even a few that came up with a totally different admissibility standard. The result is a wide variety of admissibility standards across jurisdiction, with evidence admissibility differing jurisdiction to jurisdiction and judge to judge. This is why evidence admissibility is such a complicated subject, because what's admissible in one courtroom may not be admissible in a different courtroom, or even in the same court in a different state. All right, well, that concludes the Daubert Trilogy video lecture. Thanks for watching, everyone.